You applied for a job and didn't hear back. You tried to rent an apartment and suddenly there were other applicants. All because of a domestic violence arrest from years ago that never even led to charges. And that's the part most people don't realize. Even if the case was dropped, that arrest still shows up on your background checks. I'm Nana Knight. I'm a criminal defense attorney here in California, and I've helped clients get those records sealed so they're not punished for the rest of their lives over something that never even went to court. This video breaks down exactly how the process works, who qualifies, and what steps you need to take to erase that arrest from your record so you can finally move on without your past showing up every time someone runs your name. Let's clear up the biggest point of confusion right away. There's a huge difference between being arrested for domestic violence and being convicted of domestic violence. If you were arrested and then never charged, or the charges were later dismissed, or you went to trial and were found not guilty, that means there's no conviction on your record. But here's the part that surprises people. That arrest can still sit on your record and show up in your background checks, even if you did nothing wrong. So today, we're going to talk about how to erase your arrest record in California in situations where the law allows it. We're going to talk about the Penal Code section 851.8. In many cases, the legal tool in California is the Penal Code section 851.8, often called the Petition for Factual Innocence. If you qualify and you win, the law requires agencies to seal the arrest records for a period of time and then destroy them, and the arrest is treated as though it did not occur. But this is not automatic. You have to request it, and you have to meet a specific standard, and this is about proving factual innocence, not just the case was dropped. This process is generally aimed at people who were arrested but not convicted. So common situations include things like when you were arrested and no charges were ever filed, or charges were filed but the case was later dismissed with no conviction, or you were acquitted at trial, which means the jury found you not guilty. So here's the key. You're not just asking the system to clean it up. You're asking for a finding by the judge that there was no reasonable cause to believe you committed that offense. And there's also a timing issue. For most modern arrests, the petition is generally required within 2 years from the arrest date or the filing of the accusatory pleading or the complaint, whichever is later. Though the court can sometimes waive the time limit for good cause with no prejudice. And once you believe you qualify, you need documents. You're trying to build a clean, organized story that makes it easy to see that you're factually innocent. Examples of helpful items include arrest reports or booking information, or proof the case was never filed or was dismissed or ended up in a not guilty, a verdict. Court minute orders or dismissal paperwork could be sufficient, and any evidence supporting innocence, messages, videos, witness statements, timeline proof, anything that clearly shows that you didn't do this, that you did not commit this crime. The stronger the evidence is, the better, because the burden starts with you. And here's how the process typically works under Penal Code section 851.8. If no accusatory pleading was filed, as in no complaint was filed, you can petition the law enforcement agency with jurisdiction over the offense to destroy its arrest records, and you must serve a copy of this request on the prosecutor. And the agency and the prosecutor have a defined response framework, and if the petition is denied or effectively denied, you can take it to court. California's Department of Justice also provides forms related to this process. If it goes to court, expect a hearing, a process where both sides can present evidence and the court can consider materials like declarations and police reports. But here's the standard that matters. The court cannot grant relief unless it finds that no reasonable cause exists to believe you committed the offense. And the burden works like this. You start by showing that no reasonable cause exists. If you make that showing, burden then shifts to the respondent, the prosecutor, for example, to show reasonable cause exists. That's why this is not the same thing as my case got dropped. Okay, if relief is granted, the law provides that the records are sealed for 3 years from the date of the arrest and then destroyed, and agencies, including the Department of Justice, are notified and must do the same. And importantly, Once you're granted relief, the law says that the arrest is deemed not to have occurred, and you may answer accordingly on applications when there's questions about that. Now, there are exceptions and edge cases. For example, the statute includes rules about records not being destroyed during certain related civil lawsuits and about limited admissibility rules. There are such rules, which we're not going to get into for the purposes of this video. If the judge denies the petition, that's not always the end. Sometimes it means the evidence wasn't strong enough yet. The story wasn't organized clearly or presented clearly, or the timing and the procedure weren't handled correctly. The statute also provides an appeal path depending on the type of case that you have. Here are the big roadblocks. One is waiting too long. There's a general 2-year deadline that trips people up, even though there can be exceptions with good cause. 2, weak evidence. Remember, the standard is factual innocence, which is no reasonable cause. 3, treating it like a formality. This isn't automatic. You have to fight for it, and it isn't a checkbox sort of process. 4, doing it solo by yourself when the stakes are high. You don't always need a lawyer, but when your career, your license, your custody situation, or your immigration status is on the line, having an experienced attorney can make a difference. So people ask sometimes, is it worth it? If a domestic violence arrest is popping up on your background checks, employers are asking you about it, and it's affecting your housing, your immigration, or forcing you to explain yourself over and over again, yes, it could absolutely be worth it. You're not just clearing your paperwork, you're buying back options, peace of mind, and your reputation. So let's do a quick recap. Here's the clean summary. Confirm no conviction and identify your case outcome. Build evidence that supports factual innocence. File under Penal Code Section 851.8 with the agency or the court, depending on your case posture. If needed, go to court and prove that no reasonable cause exists. And if granted, your records get sealed and later destroyed, and the arrest is treated as not having occurred. If this video was helpful to you, you need to watch my next video, 5 tricks that cops use during DUI traffic stops, because a lot of people think a DUI stop is just about a breath test, when really it's a series of tactics that are designed to collect evidence fast. Check it out now, and I'll see you over there.